Hi there, you're with BQ Prime, and we're coming to you with more sort of insights on the expert committee report on the Adani-Hindenburg public interest litigation matter. As many of you would know, the committee report has now been made public. The committee was supposed to look at the various aspects related to market volatility, whether SEBI has done a sufficient assessment of the situation, and whether or not there was a regulatory failure in looking at some of the allegations that the Hindenburg Committee had pointed out. The committee was also asked to suggest several measures to strengthen the framework in investor interest. Joining me now is Senior Advocate Siddharth Luthra on what he makes of the committee's report observations and in what direction the case is likely to move from here on. Mr. Luthra, many thanks for finding the time to speak with us. Your first quick thoughts on the remit that was laid out for the committee and whether or not the committee has sufficiently answered the questions that the Supreme Court had asked it.
So, personally, essentially, the committee says that there seems to be nothing wrong. Everything is, in the context of the Indian market, it indicates that there has been no regulatory failure. The ED gives a clean sheet. And wherever the committee has not found any answers, they've said, well, we've tried, but we've not been able to get information. So that seems to be the essence of what they have stated. Of course, they're entitled to say that, broadly speaking. But having said that, I think we've got the ED, which was also roped in. And, the ED, to my little limited experience, is a very suspicious organization. If this is their approach on any transaction, I'd be happy to apply that to all the other cases that I do. Having said that, I think I'm not suggesting that there is anything wrong, but at the same time, I would have thought that there would have been a little more introspection and a little more depth in the reasoning and the conclusions of the committee. This is not a judicial body. This is a body tasked with a specific investigation, and therefore, it being an investigative inquiring body, it had to proceed to see matters from the perspective of an investigator and not from the perspective of a quasi-judicial or judicial body. And the exercise they seem to be doing is they're almost applying the the principle which we apply in criminal law, proof beyond reasonable doubt. That was not their remit. Secondly, it's always difficult for committees, especially where you have regulators from the same individuals from the same body, to say that there are no issues. The fact that the Adani Group has taken efforts to try and assuage and to ensure that investors are comforted and that the Adani stocks have stabilized, though not at the previous rates, are all matters which are subsequent events. The remit is specific. And if you were to be kind of just to see the opening words of the committee, the remit is specific. Whether there's a violation of the rules, they've kind of answered that. Whether there's been a failure to disclose transactions, they've gone on the face value. And they've taken a view, of course, that there's no non-disclosure. And thirdly, whether there was any manipulation, to which their answer really broadly seems to be, look, there's a limited, the Adani Group has a very limited exposure, and there doesn't be any impact on the stock markets. So therefore, I think it's a matter where the report perhaps will have to undergo some amount of scrutiny by the courts, and that's the whole purpose the court had called for the report.
Okay, I have a couple of questions on the observations you've made that the committee could have probably done more into going into the factual matrix.
The conclusions may not have been different. The conclusions may not be different at all.
Right.
But the point is, I think perhaps the process has not been the way it ought to be. I think as an inquiring body, their remit was to say, look, we've inquired so far. these are our conclusions. This is what we don't have information for. And either give us more time or we'll get back to you. It's not enough to say, look, we've not got any information, therefore we treat it as a closed matter. That was not their remit, not
Yeah.
as per the questions
So,
framed by them.
which is what my next question is, that on several of the issues, and maybe rightly so, the committee has said that look, the market regulator is investing those issues, whether it is MPS, whether it is related party transactions, whether it is price manipulation, and until the regulator sort of concludes its report, it's very difficult for us to say whether there was any regulatory failure or wrongdoing in the market, if I can broadly term it that. Do you believe that this is then just the first cut of the committee's work, or the Supreme Court will further ask the committee to, sit in judgment of some of these issues as the market regulator completes its investigation?
The whole purpose to have this committee examining the issue was to restore public confidence in the processes and not just leave it to the regulator. For the committee to step back and say, well, the regulator is looking at it, so we can't comment. It is not the job of the committee to scrutinize the decision making of the regulator. It was the job of the committee to also see whether the regulatory failure. And if that's the case, then I would say that the reluctance of the committee to go deeper is a matter which will be looked at into by the court, I would assume, and the court will then determine and adjudicate on it. That's
Okay.
to my mind going to be the matter which is going to be adjudicated and debated in court when the matter is next heard in court.
Okay. There are certain aspects that the committee has, on certain aspects, some observations that the committee has made, which tell me if you think will give direction to the regulator's investigation. On some aspects, let's say on the foreign portfolio investors issue, they've said that the letter of the law, the ask of the letter of law is that you disclose beneficial ownership. Now, there could be more economic interest behind those disclosures, but the letter of the law has been complied with. So while SEBI is suspicious that there is wrongdoing, they can't find fault with the disclosures. Similarly, for related party transactions, they've said that look, while SEBI has been reiterating and refining the language of its regulations to expand the scope of RPTs, you can't, because some of the allegations allude or sort of hint in that direction, that you're using today's regulations and comparing and then contrasting the transactions on basis what maybe the existing framework is or what's supposed to come in next year. Is that then a hint to SEBI to sort of, while it's investigating on these issues, to confine itself in this broad commentary?
So the SEBI is a regulatory body whose functionality and investigating powers are governed by law, and they are not bound by the committee. They have to go by the remit given to them under the law, under the statute and the regulations, and they will have to investigate every aspect on that basis. Will the committee's findings influence the SEBI? Practically, they might. Legally, they ought not to. Of course, if the committee has highlighted aspects that are important to be investigated, SEBI ought to investigate those powers. It is important or it is crucial for SEBI to investigate those issues. So having said that, my sense is this. Some of the issues that the committee, as you rightly pointed out, there are certain findings they have sought to make on the issues regarding the nature of regulatory framework that applies. Having said that, it is also important to say that has the committee gone beyond its jurisdiction in opining on matters which are the domain of regulators? It can't be a situation where on the one hand you say, there's a regulator, let the regulator determine. On the other hand, you say, well, I think this is the way the law ought to be applied. So we can't have it both ways. And therefore, I believe there is some level of contradiction in the committee's report. Okay. And I'm hopeful that when this matter is dealt with by the regulator, they will apply the full force of law and examine the matter threadbare Because what is important is for the court and for the citizen that we get the entire detail of information that is to be obtained from this process.
Okay. All right, Mr. Luthra. I'll apologize to my listeners. There has been some sort of audio glitches in Mr. Luthra's responses, but I do get the broad point, Mr. Luthra, that you're making, that there was more in terms of the process that the committee could have done. While we see ED and CBI responses in some of the aspects, I'm not sure to what extent the committee has done an independent assessment. At a lot of places, we have seen them rely on what SEBI has given to the committee. But again, to be fair, in the 2 months that the committee had, I'm not sure how much of an investigation the committee could have carried out. Mr. Luthra, as we all go into the report in greater degree of detail, we'll come to you with your more thoughts on some of the investor strengthening measures that the committee has suggested. Stay tuned to BQ Prime.
Thank you, and my apologies for the bad connectivity.
No problem, sir.